Hey gang, Stephen Marshall, KYLandlordlaw.com, and back with another update as we are rolling towards June the 1st, which is the day that the Supreme Court has said the courts can open back up. And the question that is on everyone's mind is, when can we file evictions? So I wanted to give you a video on where things stand right now and what we can expect in the days ahead. By way of a little bit of background, you remember on May the 8th, the governor issued a new executive order that allowed evictions to move forward except those based on non-payment of rent at residential properties. So, according to the governor, since May the 8th, any eviction at a commercial property can move forward, and evictions at residential properties can move forward as long as they're not based on failure to pay rent. The problem's been that the courts throughout the state have been closed to eviction filings. Well, the good news is that is about to change. I'm on the Supreme Court's eviction subcommittee, and we've spent about 4 hours on Zoom over the last couple of weeks discussing how we can appropriately open up the courts across the state in compliance with the governor's order and in compliance with the CARES Act. And after those meetings, here's what I expect you're going to see in the days ahead. You're going to see a new order from the Kentucky Supreme Court by the end of this week that allows all evictions to move forward in accordance with the governor's order effective June the 1st. So that means that local courts are going to be accepting eviction filings that are for commercial properties or that are based on something other than non-payment of rent. Now, there is going to be something new. There's a new form you're going to have to use in which you verify as the landlord that you're in compliance with the governor's order. If you file an eviction that is not currently allowed by the governor, the court is going to have the option to dismiss your complaint and issue sanctions against you for violating the governor's order. So what that means is that before you file an eviction, you need to make darn sure that your filing is not based in any way on the tenant's failure to pay rent. Okay? Now, obviously, you can't file a straight non-payment of rent eviction, but your eviction cannot also be based in any way on the failure to pay rent. So, for example, if you had a tenant whose lease expired recently, or a tenant who was a month-to-month tenant, and you refuse to renew that lease, or you refuse to renew that month-to-month tenancy because they had not paid rent, that eviction is still prohibited. If your tenant had been violating the lease before the COVID-19 pandemic, and you'd kind of allowed them to do that, you'd turned a blind eye to it, but then you decided to enforce your rule once they failed to pay their rent, that eviction is still prohibited. So any eviction that is motivated by the failure to pay rent is still prohibited. You cannot use other violations or loopholes as a pretext to evict a tenant who's not paying their rent. And so when you file your eviction complaint, you certify to the court that the reason for the eviction is not in any way related to non-payment of rent. And if the judge finds that you violated that certification, in essence finding that you lied when you made that certification, you can be sanctioned by the court. And nobody wants that. So the good news is that starting sometime in early June, you'll be able to file evictions that are based on something other than the failure to pay rent. Now, the exact date when the courts are going to allow that is going to vary from county to county, but it should be happening everywhere in early June. Okay, maybe not June the 1st, and maybe not even the first week of June in every single county, but it's going to be happening soon in most counties. Now, I know that the real question that everyone wants answered is, when can we file non-payment of rent evictions? And unfortunately, there is still not a clear answer on that. Okay? Now, you know that for CARES Act properties, you're going to have to wait until July 26th, send a 30-day notice to pay or vacate then. For non-CARES Act properties, you're waiting on the governor to do one of two things. He's either going to have to lift the state of emergency, or he's going to have to issue a new executive order that allows all evictions to move forward prior to the state of emergency being lifted. Now, it's my expectation and my prediction that number 2 is going to happen before number 1. Okay, our state's ability to receive federal funding in certain regards is tied to the state of emergency remaining in place. And so for that reason, I don't think the state of emergency is going to be lifted until the last possible moment. And so that means we need the governor to issue a new order that allows evictions to move forward even though the state of emergency is still in place. The bad news, in all honesty, I don't think he'll do that before the CARES Act expires, which is July the 25th. I hope that I'm wrong. We can hope for the best. We can prepare for the best. I think you can probably go ahead and give notices to pay or vacate once June rent becomes past due. The governor may disagree with that, but that's my advice until I hear differently. But even though we do that, it is my prediction that we will not be able to file non-payment of rent evictions on July the 1st like I had hoped originally. So, next question. What does this mean for evictions that were filed prior to the shutdowns? Okay, there were a number of cases that were filed back in March but didn't get to have their hearing before the shutdown, before the court started closing. If that's you and your case was based on non-payment of rent, you're still on hold, okay, until the governor issues a new order. But if your case was based on something other than non-payment of rent, you can move forward. Now, you're going to have to complete and file one of those new verification forms. And those will be released sometime after the court's new order, which I expect to be by the end of the week. You fill out that form, have it served on the tenant, and you're going to get a new court date to have your case heard. Okay. A question to clarify my last video on the CARES Act. If you haven't seen that, make sure you watch that video. It is very important to know whether your property is covered by the CARES Act or not. But the question I got, and that I did not make clear in that video, if I have a few Section 8 tenants, does that mean that all of my properties or all of my units are covered by the CARES Act? No. Only those units that house Section 8 tenants are covered. I told you in the video that if you have a property that is project-based Section 8, it's covered by the CARES Act. And any properties that are accept Section 8 vouchers on the tenant side are covered by the CARES Act. But it's only those individual units when it's on the tenant side. So if you have a property that has 30 units and only 6 of them accept Section 8 vouchers, and it's not otherwise covered by the CARES Act based on a federally backed loan, then those other units, those non-Section 8 units, are not covered by the CARES Act, and you can deal with them in the normal manner. I don't think I made that clear in the first video. But then one other thing on the CARES Act, when evictions are allowed to be filed again based on non-payment of rent, you're going to be required, more than likely, to prove to the court that your property is not covered by the CARES Act. Okay? So you're going to have to show that in some way. My suggestion is to start acting now and get a letter from your lender that addresses those 3 questions about your loan from my last post. Okay? And you can check out that post for the details on those questions to ask your lender and to get your lender to verify. And I'll have links in this post to do that as well. And then final question, when are we going to be allowed to open our pools? I think that's going to happen is the good news. The governor has kind of moved on that. He's requested recommendations on opening pools at apartment communities. J.D. Carey over at the Apartment Association of Kentucky has worked very hard and has sent in recommendations. That was done a while back. The governor has not acted on those yet. I think partly because he did not want things to open up before Memorial Day weekend. But I'm hopeful that we're going to get an update from the governor soon on opening pools at apartment communities. And I think that's going to happen sooner rather than later. So I think that's it for today. That's the update. I will post the new Supreme Court order on my Facebook page for Kentucky Landlord Law once that comes out. And as soon as I know anything different than this, I'll give you a new update. But that's where we are for today. Hope everybody had a fantastic Memorial Day weekend and have a great rest of your week. If I can help you in any way, make sure you reach out. Our phone lines here at the office are open now, 859-685-0035, or shoot me an email, smarshall@trippleslaw.com. You guys have a fantastic rest of your day. Take care.